Thanks very much, everybody. So, a great introduction. So, I'm Rupam, customary slide with a picture of myself. I'm a partner lawyer at Harbottle Lewis in London, do all things technology in video games. And I'm here to give you a brief overview of what the things you should be thinking about from a legal perspective if you're either developing an AI product that you want to bring to market, or you're licensing an AI product in, which you then want to put into a game and kind of put forward to players. So, the things that I'm going to be talking about, firstly, as you'd expect, the regulation of AI. What are the main laws you should be thinking about, both domestically and internationally? When you are looking at actually deploying an AI agent or any kind of AI tool in a game, the thing that you should be thinking about most from a lawyer's perspective is the contractual matrix. Who are all the parties involved? We'll be diving into that. Got quite a complicated slide to go through. And then finally, very briefly, I'll be touching upon intellectual property, who owns what, the questions you should be asking yourself whenever you're dealing with AI. I'll only be doing it briefly because after my presentation, there's a break. And then another lawyer, Anna, from another law firm, is going to be presenting more specifically on the intellectual property points and considerations everyone should be thinking about. I'm happy to take questions as we go through, or we can wait till the end and you can go around with the super squeaky mic. It's up to you. So, without further ado, AI regulation. So, let's start off with the UK position on the regulation of artificial intelligence. Currently, we don't actually have a singular law that governs how AI should be deployed, what you can and can't do with it, how the intellectual property in it exists, etc. Consequently, when you're looking at the deployment of artificial intelligence, you kind of have to look at the mismatch of the various laws that already exist in various different disciplines to understand how that applies to you. And that can be complicated, but essentially what you need to be thinking about are contract law. Who's your contract with in relation to the intellectual property if you're bringing it in the AI? You need to be thinking about consumer law. If you are deploying the AI in a game, how are you dealing with the gamer, with the player? How do they understand what they're dealing with? What are the terms that you've got in place with them? And as you'll all be super familiar with, I imagine, GDPR, data protection. How are you dealing with data? How is it getting sucked up into the tool, the agent, whatever it might be? And how is it being processed? Are you being transparent in relation to the processing of that personal data? You also need to have one eye on how the regulators in your industry, essentially, are thinking about AI. In the game sector, that's principally Ofcom. And they are sort of in the beginning stages of thinking about artificial intelligence. They haven't come out with any particular rules or particular guidance yet in relation to how AI should be deployed, but it's something that's happening. There are some kind of mission statements, some kind of loose thinking, but nothing that actually is binding at the moment. One asterisk to this, about 2 weeks ago, the UK government kind of made a point of saying that AI legislation is coming, and is coming in this parliament. So we should expect maybe in the next 12 to 18 months to have a bit more clarity on what the UK's position is sort of strategically on the regulation of AI across like all sectors and industries. But at the moment, we don't have that, so we have to look at all these laws to form a picture. We should contrast that with the EU position, which is essentially the opposite when it comes to the regulation of AI. Earlier this year, the EU passed the AI Act, which is now in the process in various different stages and coming into force. That is a wholesale regulation of the deployment of AI in the European Union. And the following slides, I'll go into that in more detail because it's super important. And it gives you a really good understanding, gives everyone a really good understanding probably of where the direction of travel is going in relation to how the law will look at AI going forward. And finally, it's important to think about other jurisdictions in which your game might be played, where the tool might be deployed, and different countries have different approaches. China actually has a very developed regulatory approach to AI. They've really thought about it, and they've got like quite deep, hard kind of legislation on it. America is a bit more like us, it's a bit more piecemeal, but they have a much more state-by-state approach. So while not relevant to video games, it's interesting that some states, for instance, in America already have banned autonomous vehicles. And that's the kind of granularity you get with AI in the States. Individual states are doing different things, so you can see a situation when like California might take a different approach to New York in relation to how AI might be used in games or really any vertical. But moving on to the EU position, which is super relevant for all of us, because it has wide effect, a bit like GDPR, the data protection legislation. Essentially, if you're deploying an AI system within a game or really within any vertical that affects a person within the European Union, the act could bite. And to be honest, the reality is, if you're deploying any game via Steam or via really any store, you're going to want to reach players within that block of countries that forms the European Union. And as a result, the EU AI Act, when you think about it from the fact that it's covering the whole of the European Union, is going to affect all of us, whether or not we're based in Europe or not, just by the nature of the way the games are kind of sold and the players who use them. The EU AI Act has this huge territorial effect that we should all be thinking about. It also kind of sets the bar for what best practice might look like going forward. So it's a good barometer of, am I doing things, legally speaking, which kind of comply with the general accepted practices the world's going towards with AI. So what does the EU AI Act do at a high level? It blanket bans a list of specific actions which you just cannot do in relation to players, users within the European Union. There's a long list, but in particular, one that's quite interesting and one that I've kind of pointed out is you can't web scrape facial identification kind of images. So if you're ever thinking, and it's the one that most relevantly applies to video games, but when you're kind of going through the internet and scraping personal information, I'm not saying you would, but if you were looking to take information off the internet and use it to identify people, that's something that needs a really good, clear thought before it's done, because the AI Act is very specific about that. Secondly, it sets out a bunch of risk levels in relation to what you can and can't do with AI. So it's almost like a pyramid of risk. So you've got high-risk systems. As you'd expect, high-risk systems have a very high level of obligation in relation to what you can and can't do. Then you have limited risk systems, which you have to comply with certain requirements and not others. And finally, minimal risk systems, where essentially you don't have to do very much at all. In addition to that, it sets out roles and responsibilities depending on what you're doing. And I know in this room we've got a variety of people. So if you're a tech company building AI models, AI tools for use in video games, you would be a deployer, and you have the highest level of obligation. You need to really think about how you're developing your tool and how you're going to take it to market, and kind of start at the center of it from a perspective of being transparent with gamers, essentially, and what's happening. If you're a deployer, so you're a studio, you're licensing in a tool which is already out in the market, you still have responsibilities, but they are at a lower scale than the deployer. And then a distributor, that's really if you're reselling the tool, you're not the studio, you're not the developer, but say you found a tool in the States that you want to bring to the market in the European Union, you'll still have some responsibilities. They will be lesser than the person developing it, but you still have some. And finally, importer, that's sort of where you're bringing a foreign tool in, but you're not distributing it. It's probably not relevant for this audience. Once you've gone through this list, what is the risk level of the tool? What is your role within it? The final thing to think about is, does it have a special status under the law? So in particular, the one to think about is the European Union is super interested in general purpose AI. And there's a whole load of rules and responsibilities around that specifically, which could bite. Again, probably not relevant here right now, but you could see in the future a particular general purpose AI being developed for the purpose of video games alone. And for sort of public policy reasons, the EU has taken a very kind of robust approach to how you should do that across all use cases. In terms of how the act comes into force, it's been signed and it's on the statute book, but the majority of the obligations under it won't come into force until essentially 2 years from now, the 2nd of August 2026. A few start earlier and a few start later, and I'll come on to the one that's most relevant probably for people in the game space on the next slide. And being a lawyer, I have to talk about the reason why we do this, apart from because you have to, because it's compliant with law. What happens if it goes wrong? A bit like GDPR, there's the prospect of massive fines and reputational risk if it goes wrong. So I picked out one of the potential fines, which for breach of one of the obligations, you've got a potential risk of being fined 7% of global turnover or 35 million euros, whichever is the greater, which is obviously huge. which is sort of the carrot stick, the stick against the carrot of making sure you're compliant. So when you're looking at deploying an AI tool in your game or developing an AI tool for a game, and you're looking at the EU AI Act, the practical steps you should consider. Check the list to see if you're prohibited from doing the thing you're doing. Understand what your role is. Are you a developer? Are you a distributor? Are you a deployer? Understand which risk category you fall on. Are you high risk, limited risk, minimal risk? And then the next takeaway is to understand the obligations that fall from all of those things, and you'll eventually dilute yourself down into like, this is what I need to do to be compliant. And finally, when you worked out what you need to be compliant, think about the time frame which you need to do that. Now, there's like a myriad different ways and iterations and things that could lead to different outcomes for you. So I can't go through all of them. What I can say is the vast majority of deployments that I've seen personally, having lawyered studios and developers so far in the video game space, fall into this category of what you need to do at the end. Typically what we've seen is the deployments end up being limited risk, which means they aren't considered to be incredibly onerous and difficult from an EU perspective, but they are caught by the Act. And if you are within that category, in the vast majority of deployments, you find what you need to do is comply with the obligation of training your staff in AI literacy. And that essentially means everyone who's involved with the deployment of the game and the use of the tool, and the AI tool more specifically, need to be trained in being AI literate, understanding the pros and cons, et cetera, and kind of thinking about the ethics of the deployment. You'll find if you're ever as boring as one of the lawyers in the room or myself, and actually look at the legislation, there's a worryingly small amount of detail in the actual legislation about what AI literacy is, but I'm sure what the market will come to a view into like what AI literacy means for different people in like the deployment of AI tools. The second thing needs to be, and this is a longer time frame, is be transparent with the players about how they're dealing with AI. So the Act says, essentially, I'm paraphrasing, if it's really obvious to the player they're dealing with AI, that's fine. You don't necessarily need to give them any further notice. But if it's not obvious, then they need to be made aware of the fact that AI is going to be involved. And typically the way that that's being done at the moment is by developing kind of statements and notices to explain how AI is used in the game. That leads me to the final point, which is what should you be doing right now if you're a studio? You should probably be thinking about your AI governance. And I imagine that will come up time and time again in these kinds of talks. In an ideal world, you'll have an AI governance policy, you'll be thinking about it. So whenever a new AI use case is put forward, it gets sort of filtered into the governance policy, and the policy will say, okay, what kind of tool is it? What are the ethics behind it? How are we going to make sure that it doesn't unfairly prejudice a particular demographic of player? And then also there'll be a line item, have we thought about the legal consequences? Have we thought about the transparency piece? How is that going to fit through? So when you go through that flow chart, that workflow, you make sure you're always kind of catching up and making sure everything's sort of in proper order. So that's the EU piece. And then finally, I'll just really quickly say this because it's not actually AI relevant, but I couldn't help myself. Just remember to think about GDPR, data protection compliance, consumer law, and the myriad laws that are now in force or coming into force around digital harms. So if you're deploying a game that's using AI, you're very likely to also be caught by a bunch of other legislation to do with policing the development and deployment of content to players. So you've got the UK Online Safety Act, which is to do essentially with user-generated content, and the EU Digital Services Act, which again is to do with giving content via online platforms to consumers, or in our universe, players receiving content via multiplayer games typically. So contracting for AI, as promised, here's the complicated slide. Now, if you are a lawyer yourself, or if you're dealing with a lawyer, this is typically how a lawyer will try and think of like the stack in the ecosystem from a contractual perspective. So I think it's just really helpful to see it, and then think about the contracts and the relationships that exist in like a typical AI deployment. Let's take the view of the games company, so the studio that's deploying some AI, and let's say the studio isn't developing it in-house. It's licensing it from someone like OpenAI or AWS, who were speaking earlier, whoever it might be. So you're the game studio at number 2. What are you thinking about in terms of your contract? You have, obviously, a contract with the player. That will be your EULA, your end user license agreement, and you also have a privacy notice, which technically isn't a contract, but it's a part of the relationship between you and player. They have the terms of sale with whoever they bought the game from. They may have bought it from your own store, they may have bought it directly from you, but more likely than not, they bought it from Steam or from the PlayStation Store or whatever it might be. Going down a rung, number 2, games company, you will have your own terms with the store to think about. And then more importantly for our purposes, you'll also have some terms of service with the AI developer who developed the AI tool, which you should be super focused upon when you're contracting for this stuff, because that is the fundamental relationship between you and the person, company, who have developed the tool. And you should be thinking very carefully when you're taking a tool around a number of points in those terms. You should be thinking about, what's the standard of service am I getting from this tool? If it's live and it's kind of dealing with live ops, so they're managing the back end, they're not just giving you the tool, but they're running it via the cloud. What's the uptime? What's the downtime? How's that going to work with my worldwide audience of players if it's going to be like a 365 sort of service? You should importantly be thinking about ownership of IP. The developer will almost certainly say that they own the IP in their tool, quite rightly, because they developed it. But what happens if you are feeding your own intellectual property and content and prompts into the tool? Who's going to own? Are you going to own your prompts? Are they going to own the prompts? Typically, they might say you continue to own your prompts, but to the extent that they don't contain your confidential information, they should be able to be used by the developer to help improve the service. And on paper, that's great, right? Because the tool's going to get better and better the more and more you use it. But if you are a big studio, you might wonder, well, what happens if the developer licenses the product to one of my competitors, and what I'm essentially doing is training the tool to get better for the market at large? That could be fine, it might not. It's something to think about. It will definitely be in the small print. You should also be thinking about, if things go wrong, what happens if the tool develops, let's say it's generating artwork, and it develops an image that you put into the live run environment, and that image looks incredibly similar to an image which one of your competitors uses in a AAA title. And that other competitor comes along and says, hey, the image in your game looks incredibly similar to our own, take it down. Should you be responsible for that? Should you be liable for any potential legal actions that flow from it? Arguably, if you were taking the point of view of the games company in number 2, you might say, I shouldn't be. And the only way that you can't be, really, is if you've dealt with it in your terms of service via an indemnity or a warranty or something to say, in that event, developer, you'll make me whole because it's not my fault that your product created this particular harmful content. Moving on from that, you should also be thinking, when you go down further from the chain, so you look at row number 3, AI developer, their product is going to be predicated on a whole stack of third parties, almost certainly. So if you are looking at this from the perspective of the AI developer, they are going to be looking down the chain at rights holders, people who have licensed content to them to train the model, if it's an LLM. They will also be looking at licensing terms and hosting terms if they are running it via the cloud, if they're running it on a Microsoft Azure operation, or if they're using AWS. That's all relevant to them. So if you're the AI developer, you have the question mark over who owns the intellectual property, how was it developed, who owns the software code. On top of that, they've got to think about the data that's gone in and the ownership of that data to train the thing. And then they've got the various terms that flow into how do I run the thing, the operational bits. And this is the overall structure. No matter where you sit on this, apart from if you're number 1 the player because you just want to play the game, that everyone should be thinking about. And when you are dealing with everyone in this stack, it helps, I think, to look at it from this perspective because it gives you an idea of where everyone's perspective is on it. So, moving on again, finally, intellectual property. Now, as I said, Anna Porter-Jones is going to be covering IP after the break, so I'll keep this short. But where you are deploying a AI tool, here are some questions that I would say it's worth thinking through and maybe think through them when Anna's giving her talk, and it might sort of, for those of you who are interested, give a kind of a good spin on it. So I would ask the question, what intellectual property rights were used to train the AI in the first place, and who owns them? So where did the content come from if it was a model that was trained? And was that content provided on a commercial basis? Was it provided for free? To what extent can we be confident that somebody down the line won't say, hey, you never had the right to train this tool in the way you did in the first place? Secondly, what IP actually exists in the AI tool itself? If you developed it yourself, hopefully you got your employees to do it, or you did it yourself personally, and you are confident that your various contracts with your employees assigns the intellectual property in the tool to you. If you are licensing the tool, are you buying it from a reseller who's like going up chain? So one thing we see a lot of is resellers essentially using a back-end kind of license with one of the big AI companies and reselling it rather than having it in-house. That's important to know if you're then going to deploy the tool, that actually you're entirely dependent on somebody else, like Google Gemini, for instance. Thirdly, what are the outputs of the AI and who owns them? If you send a prompt to something and it sends back a piece of content that you want to use, do you own it? Does the tool provider own it? Could it be the case that you own it, but if somebody sends the exact same prompt to the same tool in a different deployment, and it gives the exact same output, they also own that output, so you both own identical but different outputs? How does that work? And how will the AI be licensed to you, on what terms, as I said in the earlier slide? And then finally, as I said, super importantly, what happens if things go wrong? What happens if it turns out a bunch of people say they all own the same AI? How are you going to be protected from that? Or if you're the company deploying the tool in the first place, to what extent are you going to protect your customers in the event that happens? Or are you going to say, actually, that's just not a part of our business case? This is emerging technology. We can't stand behind it to that extent. We'll work it out at the time. Different opinions depending on where you sit in the supply chain. So that's intellectual property. Hopefully running to time. Yes. Okay. So 5 minutes left for questions, if anybody has any.
Just want to know, let's say, if I developed an AI solution which can generate game art based on the prompt, okay, and I give it to a gaming company, and they create a prompt saying that build me a main character which looks exactly like Shrek, and then they launch it, and then somebody says, okay, no, you don't own this. This is very similar. So, I'm not the one, I'm developing a solution which can generate art, It's up to you, and that's my understanding, I don't know who is the owner here, but, it's up to you, to see, like, what kind of prompt you're putting in. I don't control that, You want to put any prompt you want to generate any character you want. From there on, the responsibility, at least what I think, depends on the gaming company, that how they use or misuse, that particular tool, So, who's going to get into trouble?
Who's going to get sued? Okay, so there are two parts to the answer to this question. So firstly, I'll give you the practical answer to this. It's nigh on impossible for you as the AI company to completely mitigate the risk of this, right? Because you can't control the prompts that are put into your tool. However, you should at the very least, practically speaking, limit the risk of that by having appropriate acceptable use policies and moderation of your tool to prove that you have tried your best to avoid that happening. So at the very least, your contract with the studio and any user policies that are given to like authorized users, end users, developers, whoever it might be, should say, here's a bunch of stuff you shouldn't do. One of those things is to put profanity into like my tool. Another one is to like blatantly rip off other people's intellectual property by saying, give me a Shrek with a gun or whatever it might be. Not that I'm suggesting you should do that. So you've got that piece to it. Then secondly, if your tool does produce that kind of infringing content, you are at risk of litigation. If you put yourself in the shoes of the rights holder, and think about it from their perspective, what are they going to do? They're going to go to the person who created the content, and that is technically your tool, which you own, which you are licensing to somebody else to take it down, and potentially, at the very least, take it down, and potentially, if you've profited from the creation of infringing content, sue you for that profit, or loss of profit in that case, or reputational damage. So you can't get off the hook from that, because you were essentially the creator of it. To mitigate the risk of that, what you do realistically is, as I say, downstream, try and prevent that from happening, and then upstream, put in processes to allow for infringing content to be notified to you, and for you to have a process to make sure it's dealt with very promptly. So that the risk of litigation keeps on reducing, because what's the loss to the person whose content's being misused if they tell you and you immediately get rid of it and you tell the customer they can't do it again or terminate them or whatever it might be. But the answer is, yeah, you are at risk of litigation, and you have probably misused some intellectual property in that process through various, like there's 100 not 100, but there's quite a few different ways that you could have damaged that other company's reputation or misused their IP in that sense. So they've got a lot of different causes of action.
So thank you very much. I think the question maybe we asked just after. Just say we have around 15-minute breaks before we continue. Thank you again.
Thanks.